Good afternoon, everyone, and welcome to today's webinar, the 2020, the Year in Review, the Federal Sector. This is the second webinar in our 2020 Year in Review series. My name is Chris Pigott, and I'm a partner in Fasken's Toronto office in the Labor, Employment, and Human Rights Group. I'm joined today by colleagues from across the country. We have with us John Craig, a partner in the Toronto office, Jackie VanDerMeulen, also a partner in our Toronto office, and Charles Wagner, a partner in our Montreal office. Before we dive into quite a substantial presentation, I do have a few housekeeping notes. First, there will be an online survey available to everyone who's participating. At the end of the webinar, I'd ask you to click the survey link underneath the video to complete our survey. We'd ask that you do complete the survey. These surveys help us to determine future topics that are of interest to our participants, and we find your input very helpful in this regard. Second, there will be an ability to ask questions during the webinar. To ask questions, please type your question into the chat box beside the video. We will do our best to answer all of the questions that we receive. I will say that we've already received a number of advanced questions, so we may not be able to get to every question, and we would invite you to follow up directly with us after if we are unable to get to your question. If you require technical support, please click the Tech FAQs or Tech Support chat, which is located under the question chat box. If you are looking for COVID-19 specific information, we do have a wealth of information related to COVID-19 in the Fasken COVID-19 Knowledge Center, which can be found at fasken.com. And last but not least, the next webinar in our 2020 Year in Review series is 2020 Year in Review Employment Litigation, which is being held on November 23rd. Our last webinar in the series will be held on November 30th, dealing with labor relations. Please visit Fasken Institute at fasken.com for more information and to register for these webinars. Now, let's get into it. This has been an absolutely remarkable year for federal sector labor and employment law. This is partly due to the COVID-19 pandemic and the response of the government and employers, unions, and employees to the pandemic. But in the federal sector, perhaps uniquely in Canada, we are also seeing a huge range of initiatives that are not directly related to COVID-19, and they're being driven by the Trudeau government's ambitious agenda in the area of labor, employment, and human rights law, broadly defined. We will talk about a number of the different federal government initiatives that are impacting employers during the session today. But just to give you a taste of what we're going to be discussing, there has been legislative action and regulatory action in respect of employment standards, in respect of workplace harassment and violence, pay equity, accessibility, and the list goes on. And you'll see the agenda up on the screen now. And this is just a small taste of what we'll be talking about over the next hour and a half or so. I would just warn at the outset that we are not going to be able to dive into the details of every single initiative that the federal government is advancing right now, or that we will mention during this presentation. Again, we apologize for that, but we would be absolutely pleased to discuss any of these initiatives with you directly after the session today. I would note that not only has there been some legislative activity across this range of issues, and while the pandemic did initially slow down many of these initiatives, things have ramped back up. And we're seeing evidence that the federal government intends to plow ahead really as we speak across many of the the areas of reform where there has been activity. There's probably no better example than this, than the fact that the new pay equity regulations were released on Friday, and Jackie VanDerMeulen will be dealing with that during the session today. There has also been some action in the courts and in collective bargaining. We will try to spend some time on those features of the federal sector if we have time towards the end of the presentation. Last but not least, I would just point out that our goal today is to try to ensure that you are up to speed generally on what is happening. We cannot cover everything in depth. And I would invite you to reach out directly to your regular Fasken lawyer or to one of the presenters today if you have any questions about anything that's discussed or not discussed. And I'll probably say that a few more times during this presentation just to make sure the point really does get across. With that, let's jump right into the areas of legislative reform that we're seeing, and I'll hand it over to Jackie VanDerMeulen to begin telling us about pay equity. Jackie.
Super. Thanks, Chris, and thanks to all of you for joining us on this dreary Monday afternoon. So I'm going to start off with the Pay Equity Act. Again, it's going to be an introductory overview. As Chris mentioned, we did see the draft regulations come out on Friday afternoon. So if I can leave you with one thought from this presentation, it would be move this item up to the higher end of your very long priority to-do list right now, because by introducing those draft regulations, we're really starting the clock ticking on this whole pay equity process. They're not finalized yet, but again, we expect them to be finalized in early 2021. There's a consultation period. Once they are finalized, that's when all of your timelines under the Pay Equity Act start ticking. And as you'll see, there's actually quite a lot to be covered in this process. So I'd encourage you to start thinking about it in a lot more detail now. Next slide, please. So what is the Pay Equity Act at a high level? Those of you who have been operating in the federal sector know that you already have obligations as employers under the Canadian Human Rights Act to ensure pay equity across your organizations. That said, that's a complaint-driven model. So that means it requires an employee or a union to actually come forward and file a pay equity complaint and then go through what is usually quite a substantial litigation process to determine whether there is actually a pay equity issue or not within a specific group of employees. What this act does is recognizes that pay equity is not so much and not typically an individual employer issue. It's not the response of employers making decisions to intentionally discriminate against female-dominated job classes. Rather, it's a much more systemic issue across all organizations. So what this Pay Equity Act does that the Canadian Human Rights Act doesn't do is establish a proactive regime where employers across the entire federal sector have to look at and assess your compensation regimes to identify whether there are any pay inequities for female-dominated job classes. And it doesn't go the other way around. It's just for female-dominated job classes. And if there are pay inequities, then to actually proactively correct those inequities and file reports confirming that you've gone through that process. Next slide, please. So how is this going to play out? The Pay Equity Act has already been enacted, but as I said, it's not yet in force. That's going to happen when it's, excuse me, by virtue of regulations, which we expect to come through in early 2021 with the act either coming into effect at the same time or shortly thereafter. So 2021 is when it's going to start really having start the timelines ticking for employers to develop their pay equity plans. We do have a pay equity commissioner already. That's Karen Jensen, who is, from my perspective, an excellent pick from the employer community. She was a management side labor and employment lawyer and has litigated some of these big cases on behalf of employers herself. So she understands the nuances and challenges for employers, particularly with very large unions and complex collective agreements. So I'm very optimistic that when she approaches her mandate, she will have some sympathy for the employer perspective on that side, because there are lots of opportunities for her to actually intervene and make decisions throughout this process in the event of disputes, for example. Regulations, as I mentioned, you can cross out that question mark because the federal government very kindly decided to implement the regulations or release draft regulations about an hour after I finished this presentation. So you can cross that out, and sure enough, they were released in late 2020. Next slide, please, Andrea. Thank you. So to whom does the Pay Equity Act apply? It applies to all federally regulated employers, whether private sector or public sector, unlike some provinces that have just focused on the public sector employers. It applies to both, provided you have 10 or more employees. And under the Pay Equity Act, you're going to have to develop a plan within 3 years of your organization coming under the Pay Equity Act. So if you already have 10 or more employees, then 3 years after the Pay Equity Act comes into effect. And thereafter, you're going to have ongoing pay equity maintenance obligations as well. So doing that again every 5 years. Next slide, please. And that 3 years may sound like a very long time. It's actually going to be a very, very short time for some of you when you consider all that's actually involved in developing a pay equity plan. So at a very high level, what are the main requirements of the plan? And for those of you who have 100 or more employees, or if you have unionized employees, then I want you to keep in mind as you're looking through all of this information on this slide, that this work is all going to have to be done in a committee, a joint employer and employee committee. And for those of you that have experience working with committees, particularly with unions in the past, you know that even one step in this process can take a very long time when you're trying to proceed on consensus. And the Act goes through in a lot more detail what that committee has to look like, how it's formed, voting rights under the committee, etc. But still, just gathering the information alone and coming up with processes and agreeing on steps in committee is a very difficult process. So what do you have to do to develop your plan? Well, the first step is to identify the job classes within the workplace and then determine the gender predominance of those job classes. So when you're looking at determining a job class, the Act does specify the criteria that you've got to look at. So positions with similar duties and responsibilities, that have similar qualifications, or that are part of the same compensation plan and within the same range of salaries. Once you've looked at the job classes or identified the job classes, how do you determine whether it's predominantly male or predominantly female or neutral? Well, what you're doing is looking at whether 60% or more of that job class is women, or 60% or more have historically been women, or if there's a common societal stereotype associated with that job class and a specific gender. So the classic example in a provincial context would be nurses. Nurses are historically considered to be a female-dominated job class, irrespective of whether the employees in your specific job class are actually female or not. Then you do the same exercise to determine if it's male. And if it's neither male-dominated nor female-dominated, then it's neutral and it's actually excluded entirely from the pay equity exercise. Once you've identified those classes, then what you have to do is evaluate the value of the work. So you've got to come up with a method that tries to measure the skills and accounts for the effort required, the conditions, etc., of the work that's actually performed by that class. Once you've done that, you've got to come up with a value for the compensation. And important to note on this one is that it has to be an hourly compensation model. And it's not as simple as coming up with just sort of using the wage rate, for example. You really have to consider all of the different aspects that go into compensation, whether that's vacation, benefits, severance payments, various different entitlements that all go together to make up this compensation package associated with that class. Once you've got all these inputs and you've gathered all of that information, then you go on to the comparison stage. And I won't be able to get into the detail of how you do that comparison on this because it's very technical and very specific, but it is governed by the Act. There are two methods that are contemplated. Using those methods, you can then go through and figure out whether there's a wage gap or not. So, and once you've identified whether there's a wage gap or not, if there is a wage gap, you have to actually go through and make the adjustments before your plan is finalized. So there's going to be a 60-day posting period too before employees, or during which employees are actually entitled to comment on the plan. So you've basically got to have a draft plan all together with those gaps identified, proposal for correcting the gaps, and then implement the wage adjustments. If the wage adjustment is going to be more than 1% of your total gross payroll, then there are processes for actually staggering the implementation and specific timelines that are contemplated in the Act for doing that. But otherwise, you're going to have to make those adjustments before you file the plan with the Commissioner. Next slide, please. So here I've outlined a few key features of this regime. Particularly if you're familiar with some of the other regimes, this will make some sense to you, but effectively one plan is the default. So there is a process for applying to the commissioner for multiple plans to be used, but one plan is the default. And in listening to the commissioner speak last week, she very strongly suggested that it's going to be difficult to get more than one plan approved unless there are really extenuating circumstances. So that includes all of your employees, your entire workforce, whether it's your executive or not, or in various unionized groups, they're all going to be under one plan. Again, as I've already mentioned, there is a committee and there's a detailed process for establishing that committee. You're going to have to file annual reports noting your compliance with this entire process. And as I mentioned as well, there are lots of opportunities for employees to comment on the plans before they're finalized. Next slide, please. So what can you do to get ready? My biggest tip would be start thinking about this now. There's a lot to do. Again, this is all very high level overview at this stage, but each one of those steps can take a lot of work. Consider as well whether you get legal counsel, whether it's in-house or external legal counsel, to start some of this information gathering exercise and excuse me, an evaluation underprivileged before you actually get into the committee. Because remember, as soon as you're in the committee, then your employee representatives on that committee, union representatives, are going to have access to all of this data, and they're going to have their own sort of approach that they're going to push for doing the evaluations and the review and determining the job classes, etc. So to the extent that you can upfront have your own determination of how you'd like that process to play out, recognizing that you're not going to be able to determine it unilaterally necessarily, but it's still going to be very helpful for sort of ensuring that your perspective is considered throughout that entire plan development. Including considering whether you are going to be pushing for multiple plans or not. Excuse me. You are allowed to use any existing valuation systems that you might have, but with the caution that they still have to be up to date. So they have to be an accurate reflection of today's workforce, and they still have to meet the requirements of the Act otherwise. So there's some latitude there, but you still have to, there's still going to be work to be done. And start thinking about how you're going to establish that committee today, because again, those deadlines are going to come very shortly. Next slide, please. So that's my very high level overview of the Pay Equity Act. I'm going to turn it over to my colleague, John, who's going to introduce us to the changes to the Canada Labour Code. John Craig.
Great, thank you, Jackie. Appreciate that. Hello, everyone. I wonder if we can move on to the next slide. Great, that's how I know that you can hear me, because the slide just moved. To provide some context to see about what we're about to discuss in terms of reform of the Canada Labour Code, we provided you with an excerpt from the Minister's Mandate Letter of February 2017. The Liberal government made numerous commitments to reform the Canada Labour Code by filling in what they saw as gaps and by modernizing current provisions, and quite a bit of what we're about to talk about owes its origins to the initiatives that the government began to take in 2017. And you can see that one of the things that's specifically referenced in this excerpt is the whole issue of unpaid internships. And that's included in the mandate letter. Well, unpaid or poorly paid internships have been around and controversial for quite some time. In many industries, for example, broadcasting or media, internships have commonly been used and viewed as a key access point for entry into the workplace. People are sometimes prepared to work for free to get access to a potential job or to build their resumes. And the view was taken that there was a need to modernize the code on the issue to enhance worker protection and prevent employee abuse. So if we can move to the next slide. There I am. The theory behind a legitimate internship is that an employer is offering an educational and skills development experience to the intern. And while there may be some benefit to the employer from the work contribution of the intern, that benefit would not be sufficient to justify the employer paying wages and benefits as if the intern were an employee. So if we required employers to pay interns and treat them as employees, then we wouldn't have internships and the educational experience would suffer. However, there's considerable room here for abuse. For example, an employer could characterize an entry-level employment position as an internship and effectively get valuable work for free. So previously, the Canada Labour Code permitted unpaid internships for educational purposes, but didn't require the internship to be connected to a formal education program. So an employer could establish an unpaid internship on its own as an educational experience and claim that it was permissible under the code. In the 2015 election campaign, the Liberal platform included a promise to address the issue of exploitative unpaid internships. And then in the 2017 budget, the Liberal government announced that it would be amending the Canada Labour Code to eliminate unpaid internships that are now not part of a formal education program, and to establish clearly which provisions of the code would apply to unpaid interns. The amendments to the code were included in the 2017 budget implementation bill, which received royal assent in December 2017. However, the regulations were required to bring those provisions into force, and it took 3 years for those regulations to be promulgated. Presumably, according to the government at least, they felt that they needed to consult to make sure that they were taking steps that would undermine legitimate internships. So we didn't get the regulations until September 2020. And as I said, who knows why that is? Hopefully it's because of consultation. So what we now have in the code are sections 167, 1.1, and 1.2. And they were enacted in December 2017. Now, section 167, 1.1 basically says that even if you call something an internship, it's going to be treated as if it's employment under the code in most circumstances. It establishes the basic rule that you can't merely exempt a position from the code because you claim that it's an internship. So that's 1.1 in section 167. But then section 167, 1.2 includes the exemption. And it says that part 3 of the code does not apply to an intern except to the extent provided in the regulations if the person performs activities to fulfill the requirements of a program that's offered by a secondary or post-secondary educational institution, vocational school, or equivalent educational institution. So you see a clear link. Now, to have an exemption for an internship, it has to be part of an educational program and necessary to meet the requirements of that program. And now we have the regulations that allow us to understand how all of this is going to work. And there's also very handily, and I have it on my desk here, I can pull it up, if I can find it. There is an IPG that you can all download that provides a lot of guidance as well. It's IPG 102 that the government has put out, explaining how all of this is supposed to work, and hopefully will provide some good guidance as we move forward. There are case studies, the usual sort of stuff you see in IPGs. So to understand how the new regime is going to work and what the regulations say, just a few points I want you to keep in mind. First of all, the educational institution. An unpaid internship can only be provided when it's needed to fulfill the requirements of a program offered by an educational institution that's prescribed in the regulations. So it's got to be in the regulations. And what do the regulations say? Well, they're actually pretty broad. It's any post-secondary institution like a university, college, or vocational school that's on the list maintained by the Council of Ministers of Education, the provincial ministers across Canada. So that's the first thing. Or it can be any secondary educational institution that meets provincial requirements. That's a high school, for example. Any post-secondary institution or college that the federal government itself has set up would qualify. Not surprisingly, they wanted to cover that. And then you have any secondary or post-secondary educational institution located outside Canada that meets the requirements to deliver education in that jurisdiction. So if you have, for example, an educational institution in the US and it meets the requirements in the US, then it would be covered by this. So it's very broad. And then, as I mentioned on the slide here, we now know what the applicable provisions of the code are going to be where you have a legitimate unpaid internship. Unfortunately, it's really long. There's 3 to 4 pages in the regulation on this. Notably, the wage and termination provisions of the code are not included, but there's a lot that is included, specifically issues like hours of work limitations, public holidays, break entitlements, unpaid leaves. The provisions on sexual harassment, genetic testing, and anti-reprisal provisions are also covered. Next slide, please. Paperwork and record keeping. An internship can't begin until the employer receives documentation from a qualified educational institution under the regulation that sets out a number of pieces of information, but most importantly, the activities that are actually required as part of the internship to meet the educational requirements of the program. They're characterizing this as an internship agreement that would be executed between the employer, the educational institution, and the intern. And the employer is responsible for maintaining records and ensuring that the activities that take place in the workplace by the intern conform to the activities in the educational agreement. The IPG makes it really clear that if an intern performs any activities that are different from those set out in the educational agreement, or if they continue working beyond the time period set out in the agreement, then the exemption in 167 and 1.2 will no longer apply, and the code will deem employment to be, or deem the internship to be employment, and all the provisions of the code will apply. And payment to interns. If an internship qualifies under section 167 and 1.2, then it's not just that it may be unpaid, it has to be unpaid. The employer is not allowed to pay. And the IPG states that since the primary purpose of an internship is to gain knowledge and experience and education, not to provide work for compensation, therefore an employer can't pay any amount to an intern that is related to hours worked or productivity. So a well-meaning employer might think that it would be helpful, perhaps even generous, to pay an intern a certain amount for every hour the intern has been in the office, but that's a bad idea because according to the IPG, that would disqualify the internship from being exempt. Now the IPG does state that an employer can reimburse for expenses, can provide stipends for living costs, housing allowances, that sort of thing. So those are permitted. You can have a flat amount of say $6,000 to cover housing and meal expenses during the entire period of the internship, or a weekly stipend of $500, as long as it's considered to be reimbursement for expenses that the intern is incurring to do the internship. And the final point I want to make is that you can call a position an internship, but if it doesn't qualify under section 167 1.2, then the code is going to treat it as if it is employment, and you're going to have to comply with all the provisions of the code. So it's really important if you're reviewing any internship opportunities that you currently have or that you're thinking of offering, that you ensure that they meet the requirements under the code, the new requirements, because if they don't, then the entire code will apply as if it is employment. So that's all I have to say on internships, and I think we can move to the next slide, and I think Charles is taking over on unjust dismissal. Thank you.
Yes, thank you, John. Hi, everyone across Canada. Bonjour à tout le monde à travers le pays. Very happy to be with you today. Très heureux d'être parmi vous aujourd'hui. So I'll talk briefly about the unjust dismissal complaint. So if we can move to the next slide, please. So as you all know, the employee may dispute his or her termination by filing a complaint under Section 240 at ESDC labor program. The complaint must be filed within 90 days. So don't get your hopes too high. This recourse still exists. It's basically the adjudication process that is more different, more structured. Because now, once the labor inspector tries to mediate the complaint, if the parties do not reach a settlement, then the complainant, the employee, may ask the inspector to send the complaint to the CIRB. Before it was to the adjudicator. So right now, as I said earlier, and we can move to the next slide, please. It's more a structured process, more heavy, some would say, but definitely more structured. So how will it work? First of all, an acknowledgement letter will be sent to you. I said get ready because the timelines are quite small. So once you receive the letter from the CIRB, we have 15 days to answer. It's basically kind of like the labor process and any other complaints in front of the CIRB, so it's quite quick. You can always ask for a postponement if you have obviously valid reasons. And then once the employee receives the letter from the employer with the response and everything to the complaint, he or she has 10 days to respond. So that's the response and reply. We indicated details because there's a very different process now where the CIRB may adjudicate the file before or without having a hearing. So the more details that could be provided earlier on, the better it is. Because before, employers were careful not to provide too many details in the answer to the complaint. We were quite vague. And then we said, well, in front of the arbitrator, we'll provide more facts and more detail elements. Now it could be different because the CIRB may grant or reject the claim without holding a hearing. So it is very important that the submissions be accurate and detailed. There'll be an exchange of documents, so not much of an element of surprise that we had before with the simple arbitrator. So you'll need to provide all the documents to support your response, although it will still be possible under the Canada Industrial Relations Board regulations to ask for certain documents to be confidential as well. The CIRB will ask the parties if they're interested in a mediation, perhaps once the employee takes note of your answer, or maybe that you see the reply to your answer to the complaint. Maybe it will push a little more the parties to enter into a mediation process along with an officer from the CIRB. So that's still a possibility. It's voluntary, it's not mandatory, although sometimes it could be a good business decision. Now the hearing, it's very technical here because the CIRB now hears the complaint. However, the CIRB may defer its power to an arbitrator. So it's basically back to the future. So the CIRB, with the same proceeding, however, they can ask for an arbitrator to hear the case. So we're back at the same time that it was before the changes to the regulations. And then there's the decisions of the board. Next slide, please. So as I said earlier, it is in the party's best interest to file a complete, accurate, and detailed submissions in order to include all the relevant information and documents in support of your respective position. Now, if the CIRB decides to hold a hearing, it will inform the parties of the date and location. And as I said earlier, very important, the CIRB, members of the CIRB and external adjudicators have all the powers, duties, and functions conferred by the CIRB by the code regarding any matter to which they have been appointed, and their orders and decisions are considered to be the board's orders and decisions. So now I will turn it over to Chris for the changes with respect to the harassment.
Thank you, Charles. One of the most anticipated and certainly one of the most consequential changes that is happening in the federal sector this year is the coming into force of Bill C-65, which establishes an entirely new workplace harassment and violence regime by way of amendments to Part 2 of the Canada Labour Code. Now, Bill C-65 has been anticipated for some time because the legislation was actually passed about 2 years ago, but it has not come into force. And we've been waiting, with bated breath, really, for 2 years now to fully understand what exactly the new regime will look like. We now know that Bill C-65 will come into force. The new regime will come into force on January 1st, 2021. Many of the details of the new regime are really quite new because we've just received the final version of the regulations as of June 2020. And in this case, the regulations contain most of the substantive and procedural meat of the new workplace harassment and violence regime. Next slide, please. So I want to spend some time walking you through at a high level the details of the substantive and procedural elements of new framework. But before we do that, I did want to highlight a couple of the key features of Bill C-65 in the new system. First of all is the definition of harassment and violence, which is any action, conduct, or comment, including of a sexual nature, that can be reasonably be expected to cause offense, humiliation, or other physical or psychological injury or illness to an employee. Just like to highlight there, we're not only talking about physical injury, we're also clearly talking about psychological injury, and we are also talking about actions, conduct by someone that not just physical, but also could be by way of a comment that's viewed as unwanted or unwelcome. Related to this, and related to the specific reference to sexual acts, the amendments to the code are quite clear that despite the fact that this framework is going to cover sexual harassment and sexual violence, nothing here changes, eliminates, or otherwise affects the existing processes and requirements that apply to sexual harassment under the Canadian Human Rights Act. This is an entirely new layer of protections and employer obligations. Another notable feature of the new framework is that it not only applies to dangers arising within the workplace, it also arises to threats of harassment and violence that may arise outside the workplace. And so a perfect example would be something like an employee's domestic situation and any family violence, and the risk that that family violence in some way comes into the workplace. That is all totally covered by the Bill C-65 framework. And of course, as I've already mentioned, the new framework imposes substantial new or modified duties on an employer. Andrea, if we can move to the next slide, I can get into what some of those duties are. So firstly, it's important to highlight that a lot of the requirements under Bill C-65 are similar to or have the same names as many of the current requirements that exist concerning workplace violence under Part 2 of the code as it stands. In many ways, and one way to describe the new system is that we're going to be seeing enhanced employer obligations, enhanced employer duties. They fall into a couple of different categories. So for example, you'll see enhanced duties with respect to prevention and protection against harassment and violence. You'll also see enhanced or different duties when it comes to employee training. And I'll walk you through some of these in a moment. Another very important aspect of an employer's duties under the new Bill C-65 framework is that some duties, and most notably the employer's duty to receive and investigate complaints, apply to former employees. Now, this is not an unlimited application to former employees. Rather, in most cases, former employees are going to be able to make a complaint about harassment or violence, so long as they're doing so within 3 months of the last day of their employment. Now, there are some exceptions to that, and I'll describe those in a few minutes. Finally, the complaint process. It's very important to emphasize that we're dealing with an entirely new complaint process, and I'll run you through the details at a high level in just a moment. One important feature of the complaint process is that the new system very much limits the role of the policy committee, a workplace committee, or a workplace representative in receiving and investigating complaints. For the most part, committees and workplace representatives will now have virtually no role in investigating complaints concerning harassment or violence. And we'll talk about that a bit more in a minute. One related point to on-committee involvement, just before we move on, relates to the joint nature of many of the new duties. And in some respects, this may be one of the most significant new aspects of the Bill C-65 requirements. The new regulations are very clear that virtually all of the major employer duties must be jointly undertaken with the policy committee when you're talking about things like policy development and implementation. So as an employer, you will be working jointly with usually the policy committee, and if not the policy committee, the workplace committee, to implement and maintain the requirements under the Bill C-65 framework. There is an important caveat to that, which I think will be welcome news to most employers, and it is that if the parties are unable to agree, for example, on how to implement a recommendation arising from an investigation, or are unable to agree on the terms of the workplace violence and harassment prevention policy, then the employer's decision prevails in that situation. The employer's decision will prevail if there is disagreement with the policy committee on some aspect of the compliance with the requirements of Bill C-65. Next slide, please. So let's jump into the duties themselves. First category I want to touch on very briefly is our employer duties with respect to protection against and prevention of workplace harassment and violence. And again, many of these duties will sound similar to what you've already had to do under Part 2 of the Code with respect to workplace violence. First, an employer will be required to work jointly with the policy committee to conduct a workplace assessment based on risk factors that are set out in the new regulations. That assessment will need to be, again, a joint exercise through which you're identifying all of the various ways in which workplace harassment or violence could occur in your specific workplace. After the assessment is complete, the employer is required to develop and then implement preventive measures based on the assessment. Again, this is a joint duty with the policy committee. Another important employer obligation is the obligation to develop, make available, and then update and maintain on a regular basis a policy for the prevention and protection against workplace harassment and violence. This is a joint duty with the policy committee. And last but certainly not least in the area of protection and prevention is the employer duty to develop and make available emergency procedures that can be implemented in the event that there is the threat of an incident of harassment or violence occurring in the workplace. And again, that is a joint duty that an employer must undertake with the policy committee. Next slide, please. There are also a number of new duties in the area of training, employee training. An employer is required to work with the policy committee to develop and then implement or identify a training program that employees will need to undergo every 3 years. And for new employees who are starting after January 1st, 2021, the employer will be required to ensure that they undergo the training within 3 months of their first day. The employer is also required to identify what the regulations call support measures to employees. Now, these are not measures that the employer is necessarily identifying or making available itself. Rather, these are measures that are out there in the broader geographical community in which the workplace sits. And so these might be things like identifying with some provision the medical services that are available to employees if they experience harassment or violence, psychological services that may be available, and various other forms of support that are available to employees within the geographical location of the workplace. Next slide, please. Now, again, as I've already mentioned, but I'm going to say it again just so we're all clear on this, the Bill C-65 framework applies to former employees, the employer's former employees. The most significant implication of this, as I've mentioned, is with respect to the ability to make a complaint and have that complaint processed under the complaint resolution process. Generally speaking, a former employee may make a complaint of harassment or violence to their employer if they're doing so within 3 months of the last day of employment. There is an important caveat to that, which is that the minister does have a discretion under the legislation to extend that timeline in certain situations. And I think the most significant situation that we're going to see, where we will see this discretion exercised, is where the employee is able to demonstrate that they were not able to make a complaint within that 3-month window because they incurred some sort of trauma as a result of the occurrence, or because the employee has some other sort of health condition that impacted their ability to make a complaint. But again, generally speaking, a former employee needs to make a complaint of workplace harassment or violence no later than 3 months after their last day of work. Next slide, please. Okay. What many employers have been waiting to hear about, both I'm sure in this presentation, but also more generally, is what are the details of the new complaint resolution process. Now, the complaint resolution process was not made clear at all in Bill C-65 when it was enacted in 2018. Rather, all of the details of the complaint resolution process are included in the regulations that were released in June of 2020. And this system, this new complaints framework, will come into force as of January 1st, 2021. What are the key elements of the system? Well, first, the employer must designate a person to receive complaints from employees. And the framework calls this person the designated recipient, which is kind of an unwieldy term. But in short, the idea is that there's a single point of contact, whether a single person or a single department in the workplace, where the employee, which is really the first point of contact and processing area. And I don't say that in a literal way. I mean, like it's a point of contact for dealing with complaints. That's the designated recipient. Another key feature of the new complaint framework is a requirement imposed on the employer to try to resolve the issue that's been raised by the complaint at the earliest possible opportunity. Again, this is not an option that the employer has. Rather, the employer must make every reasonable effort at an early stage to try to resolve the occurrence. And it's only if at that early stage, through discussion or otherwise, the complaint isn't resolved, it's only then that you really move into the later stages of the process, including, most importantly, the investigation process. But if you are not able to resolve if you as the employer are not able to resolve a complaint through early resolution, that's where the opportunity for conciliation arises. There is a conciliation provision that basically permits a facilitated mediation or conciliation to occur if the parties all agree. So importantly, the complainant must agree to conciliation, and the employer must also agree to conciliation, or whoever the respondent is. And you must also agree on the person who's going to facilitate the conciliation. If conciliation is not available in the circumstances because someone won't agree, or that conciliation is unsuccessful, then only that's when the employer's obligation to investigate kicks in. Next slide, please. Now, I want to just emphasize that the process for receiving, processing, investigating, and resolving complaints is extremely detailed. It takes up a number of pages in the regulations, and I won't say it's a complex process, but there are some details that are relevant. What we've tried to do in this slide is highlight from start to finish, from notification to conclusion, how the process works. I want to highlight just a few points again. When the designated recipient or employer receives a complaint, you've got to move pretty quickly. You need to notify the parties who are involved within 7 days that you've received the complaint, and explain how the process is going to work. The early resolution requirements, the employer obligation to try to resolve the situation early kicks in those first 45 days. Efforts must begin. They don't need to be completed, but efforts must begin to resolve the complaint within 45 days of receipt. Okay. That is a requirement. Conciliation does not necessarily occur in every situation. Rather, it's only if the parties agree to conciliation and can agree on a conciliator to facilitate it. And this entire process, including the investigation if early resolution and conciliation is not successful, generally needs to be completed within 1 year of notification of the complaint going into the designated recipient. Again, that's a very high level overview of the details. Happy to discuss them at greater length after the presentation if there are any questions. The final point that I would make about the complaint process, and I've already mentioned the fact that the committees really aren't involved in investigations anymore by virtue of legislative changes that actually came in with Bill C-65 and not the regulations. The one exception to that is with respect to implementation of any recommendations made by the investigator. The employer is required to hand over the investigator's report to the policy committee, and then to work with the policy committee to make a joint decision as to which recommendations made by the investigator should be implemented. So the policy committee does have a big role potentially in implementing recommendations arising from an investigation. Now, again, the caveat, and I've already mentioned this, the caveat is that an employer is not required to agree with the policy committee, and the employer's decision will prevail if the committee and the employer are unable to agree on the recommendations. Now, with that, I'll turn it over to Charles, who's going to talk a bit about the group termination and layoff provisions in the code.
All right, so as Chris mentioned earlier on, all the relevant information with respect to COVID-19 are available in our website. However, we wanted to address this specific topic and to tease you a little bit in light of the new layoff extension of last November 9th and a question that we got with respect to the timing of the notice to the minister when you got 50 or more employees. So the layoff extension, if you remember well, in June 22nd, if I remember, there was a layoff extension implemented by the federal government. So certain layoff periods established were extended. Prior to that, the layoff periods a layoff was considered to be a termination after 3 months or up to 6 months if the employer provided a written notice at the time of the layoff, the recall date. After these periods, it was deemed a termination. So June 22nd, there was an extension, and now since last Monday, so the government did not publish that. Maybe the spotlight was on something else, or maybe something happening down south, but basically, so for the employers who took advantage of the layoff extension of last June, bear in mind that there's another layoff extension that we will address in the upcoming slides that has been extended. It is not available to employees if they were terminated prior June 22nd, 2020, and if their employment was terminated prior to last Monday, because the employer chose not to apply the extension that came into force in June 22nd. So basically, this extension is very helpful if you took advantage of the last layoff extension of June 22nd, and it will have an effect on the notice of group termination that you need to send to the minister. Next slide, please. So the extension. So bear with me here. So the allowable time before a layoff is considered a termination of employment is temporarily extended. So if the layoff was 3 months or less, and if it happened before March 31st, 2020, the time is now extended by 9 months after the day on which it would otherwise end. So basically, it's 12 months in total before the layoff is deemed a termination. And if the layoff occurred between March 31st, 2020 and December 31st, 2020, the time is now extended to March 31st, 2021 to recall the employee before the layoff is deemed a termination. Next slide. So if the employee had an expected recall date, as I said before, it was 6 months before being deemed a termination. Now it's, if it happened prior to March 31st, the date specified in the written notice that you provided to the employee will be extended by 9 months or to March 31st, 2021, whichever is the earliest. And the employer would have up to that period to recall the employee. If the layoff occurred between March 31st and December 31st, 2020, and that you provided a recall date, the term is extended to now March 31st, 2021, unless a later recall date or fixed period was provided in a written notice. Now, bear in mind that the temporary extension of layoff periods does not apply to employees who are covered by a collective agreement that contains recall rights, and that's very important for the next slide. A minimum work guarantee, employees on strike or lockout, receiving employer payments, for example, retention purposes, receiving employer benefits, receiving or eligible to supplementary unemployment benefits, and terminated prior to the coming into force of the changes. So the group termination. So we got a lot of questions recently with respect to when should we file a group termination if, for example, there's a recall right. So notice of group termination is not immediately required in situation where employer intends to lay off unionized employees with recall rights under a collective agreement. Now, pursuant to regulation number 30 of the Canada Labor Standards regulations, the layoff of a unionized employee with recall rights will not become a termination until the earlier of the recall date or 12 months. Therefore, employers are not required to provide minister with notice of group termination at least 16 weeks before 50 or more of those layoffs become deemed termination. Now, if you want to get practically speaking, I have different scenarios here it's actually questions that we got. So if the employer has 60 unionized employees in a single industrial establishment, and they proceed with a layoff on, let's say, December 1st, and maintain recall rights for a period of 12 months, those layoffs will not become deemed termination until December 1st, 2021. So basically, you have until August 2021 to file the notice should you decide to terminate these employees and not recalling them within that time frame. So even though it's 60 employees that are laid off, at the same time, you don't need to send the notice to the minister. Let's have another scenario where you have unionized employees and non-unionized employees. For example, 40 employees are terminated, non-unionized employees are terminated on December 1st, and 11 unionized employees are laid off with recall rights, let's say recall rights of 12 months. It is not a group termination since the termination of the non-unionized employees is under 50, and also the 11 unionized employee with recall rights, their termination is not effective in light of their recall rights. Scenario number 3, let's say you have 40 non-unionized employees who are laid off, not terminated, laid off on December 1st, and you have 11 unionized employees who are laid off on same date. So let's say 51 employees on the same date. Again, you won't have to file a notice to the minister because the non-unionized employees, obviously it will be effective you got the 1 year for unionized employee, and then for the non-unionized employees, it's up until March 31st in light of the layoff extension. And let's have a scenario number 4. Let's pretend that your recall date is, let's say, 3 months in your collective agreement. So therefore, it's the earlier of the recall date or the 12 months from the layoff. So in this case, it will be 3 months. So 40 non-unionized laid off on December 1st, and let's say 11 unionized employees with a recall rate of 3 months are also laid off on the same date. Now the scenario will be different because most likely on March 31st, you'll be in a situation where more than 50 employees of the same establishment are terminated or deemed terminated. So all in all, just be aware of your recall rights in your CBA and schedule the layoff carefully in order to avoid the 50 employees threshold. So I will turn it over to Chris for the upcoming changes to the code.
Thank you, Charles. And as we sit here an hour into the presentation, I just want to point out that there is indeed more change to the Canada Labour Code coming down the pipe. Next slide, please. And we don't have time, unfortunately, to get into the details of all of the other changes to the Canada Labour Code that are either going to be coming into force soon or that the government is canvassing with employers, unions, and others and thinking about bringing, introducing. But I did want to point out a few of them just to make sure that you are all aware of them and to emphasize that, again, the federal government is proceeding with change really across a whole range of issues, despite the ongoing impact of the pandemic. Perhaps most notably, there will, at some point in the not too distant future, be a new Part 4 to the Canada Labour Code that brings into place administrative monetary penalties, or AMPs, that can be imposed against employers for violating the code. The first phase of consultations on AMPs was completed in the fall of 2017. There has been a second phase that resulted in draft regulations being published last summer. Things have been slowed down a bit, I think, because of the pandemic, but we are still expecting the AMPs, the final AMPs regulations to be broadcast and then implemented at some point in the not too distant future. There are also a variety of changes being considered or coming into force under Part 3 of the code. And this is the federal government's modern labor standards agenda. And interestingly, the government, even over the past few weeks, past month or so, really has begun again to engage with employers and their representatives to push forward processes that had been slowed down by the pandemic. So for example, there is as many of you know, there are a variety of temporary exemptions in place for employers who are facing challenges as a result of the new hours of work provisions that came into force last year. And so these are things like the requirement to give employees breaks of a certain amount of time in between shifts. The government has restarted its consultation process with respect to the exemptions, and it will be interesting to see how quickly they try to push this forward. Similarly, the government has been discussing for some time, including before the expert panel on modern labor standards, a new right to disconnect that would be inserted into the code for employees who are, of course, facing more and more pressures, quote unquote, from email, other electronic systems that allow them to be constantly available. This consultation process has just been restarted. And there are other changes that have already been enacted by way of legislation, but are not yet in force. And just to point out a few, equal pay for equal work provisions that would prohibit an employer from paying employees differently based on the fact that they are part-time and full-time or seasonal or casual workers, but still do the same type of work. Those provisions will come into force at some point in the not too distant future. Similarly, increased entitlements to notice of termination and termination pay that have already been enacted will come into force, we expect, at some point in 2021. I could go on, but I will not, given our time constraints, but we are happy to discuss any of these changes or others after the presentation. Charles, back to you.
Yes, so I'll talk briefly about the Bill 101 and the potential extension to federal undertakings. So next slide, please. So as most of you know, in the beautiful province of Quebec, we have this Charter of French Language, commonly known as Bill 101, which is not applicable to federal chartered companies operating in Quebec. Among other things, Bill 101 requires Quebec companies with 50 or more employees to prove that French is the operating language used in their business. Now, this summer, the CAC minister, Minister Jolin Barrette, pointed out that several of federal companies already have Francization certificates, even though they were not legally required to do so. That being said, it's in the process, and we have to expect that the provincial government puts forward a modification to Bill 101. Now, other political parties have already done it. For example, the Québec Solidaire, which is a third-party opposition in Quebec, have filed the Bill 690, which is an act to amend the Charter of French Language to specify that it applies to private companies operating in a federal jurisdiction. It's a very long name, but basically it says that the bill amends only on one section of the charter, and it received 121 favor votes at the first reading. That being said, it's a political move from the opposition, although it is in line with the message sent by the minister this summer. So bear in mind that within the next year, there might be some changes to Bill 101. I'll turn it up now to Jackie for the Accessible Canada Act.
Super. Thank you, Charles. So the Accessible Canada Act, again, I've got the task of covering an entirely new legislative regime within a couple minutes. So it will be high level, but certainly follow up if you have more questions afterwards. So much like with pay equity, there are existing provisions in the Canadian Human Rights Act that protect, obviously, individuals with disabilities from discrimination. Next slide, please. But what this legislation is designed to do is a little bit different than the model under the existing model under the Canadian Human Rights Act. So again, it's a much more proactive approach. It's trying to get employers to focus on identifying and removing barriers for individuals with accessibility throughout various aspects of their organization, rather than waiting for an employee or a union, or as it may be, to file a complaint challenging an employer's practice. Next slide, please. So when we're talking about barriers, really, we're talking about all sorts of different barriers. Those could be attitudinal barriers, they could be physical barriers, whatever it might be. The Act is designed to, in a way that attempts to avoid regulatory duplication, which I'm actually quite grateful for, because I think from an employer's perspective, when you're already dealing with a lot of different administrative tribunals and regimes, it's good to have some consistency in who you're reporting to, because there are reporting requirements under this legislation. So taking broadcasters, for example, if you're a broadcaster, you're already subject to the CRTC. The CRTC is actually going to develop regulations under the Broadcasting Act that will apply to your organization and oversee the development of those regulations that relate to disability and also the reporting processes. So what that means is that the regulatory regime is going to be somewhat tailored to the specific industry you're in, although from a high level, most employers are going to be subject to a lot of the same sort of broad reaching requirements, like developing plans and doing training and those sorts of things, which I'll get into in a second. So next slide, please. So the way the Act is structured is it's got the Act itself, and then there are the regulations, which most of which are still to come under the Act. So under the Act, what do we know? We know that employers are going to have to develop accessibility plans. We know that you're going to have to set up feedback tools for receiving feedback from the public about the way you provide your goods and services to the public and individuals with disabilities in particular. And then you're going to have to publicly publish progress reports on the steps that you've taken to meet the requirements of the Act and the regulations. And importantly, what feedback you actually received from individuals under your feedback process and what steps you as an organization took to address that feedback. So if you are a large public-facing organization, that's going to be a particularly large task for you because I expect you're going to have quite a few disability groups, in particular disability advocacy groups, ensuring that feedback is provided on a regular basis through these feedback mechanisms. And it's not going to be the sort of thing that you can just address internally. You're actually going to have to publicly declare what that feedback is and how you responded to it. With respect to the plans, so we have a little bit of, the obligation is not yet enforced, so it's going to be declared enforced by regulation at some upcoming date. Our sense generally, and for this we really turn to the experience from the provinces. So you may know that Ontario has its Accessibility for Ontarians with Disabilities Act. There's similar legislation in Manitoba and also in Nova Scotia, although they're not as far along in the processes as Ontario. So in Ontario, there's a very similar requirement to develop plans and policies. And what those plans and policies do, and what we expect the similar federal legislation to require, is really for employers to reflect on what kinds of barriers they've got in their organizations and what they as an organization can do to try and address and remove those barriers for employees, for the public using their services, whatever it might be. And then to really timetable out how they're going to do that and when, in compliance, obviously, with the requirements under the Act. Excuse me. So we do have a general sense of what that's going to look like, but again, the requirement's not in force yet, and we'll have a lot more of the specific details in the regulations themselves when they do come out. Next slide, please. So talking about those regulations, what are they going to cover? Again, I'm going to draw on the Ontario experience a little bit here because these are, with the exception of the last one, the transportation, these are all still in the consultation development stage. So we don't have details of what they're going to cover exactly, but we do know from a lot of the correspondence that has gone out from the federal government on these issues, that they're targeting a lot of the similar areas that are covered by the Ontario experience. Again, that was a Liberal government initiative in Ontario, as well as Manitoba and Nova Scotia, similar Liberal government initiative in the federal sector. One of the big areas of focus is employment. In Ontario, what we see being covered by the employment standard are things like commitments to ensure that job postings contain a commitment to providing accommodations throughout the job posting or the job recruitment process, and the availability of accommodations for employees with disabilities, making sure that notice is provided. Developing individualized accommodation plans. So when you're accommodating an employee who has a disability, rather than simply going through the accommodation process, actually documenting what that process is. Those sorts of things. I won't go through each one of them again because we don't have the time to cover that today, but we expect most of the meat to be in really the employment one is going to be the significant changes. Also built environment addressing sort of things like sidewalks and very technical specifications regarding how those are developed, parking spaces, those kinds of things. Websites is another one that's been really big in the provincial sector and is just coming into force now. The more significant requirements are coming into force now, where you've got to ensure that your websites are developed in such a way that the sort of building blocks of the website itself are accessible, meaning that someone who has an assistive device can actually interact with your website using that assistive device, and the web content that's on that website is similarly accessible. So you don't have a lot of images. Instead, if you do have an image, you've got a little text box that pops up and identifies what that image is, again, for someone with a vision impairment, for example. So lots of really specific requirements like that. The good thing is that the legislation is designed to be a gradual approach. It's not designed to all come into force at once. And we saw that with Ontario too. All of these requirements were staggered over some time so that employers had at least a little bit of leeway to develop their compliance plans and roll out those activities, because they otherwise can be very significant if they're all upfront. As I mentioned, the transportation one is already out. When we're talking about transportation, that one's really focused on sort of public transportation, so trains, planes, buses, those sorts of things, ferries, and really, again, technical specifications. A lot of the deadlines for those were pushed back in recognition that the transportation industry has been hit extremely hard by the COVID pandemic. So some of the more onerous requirements were pushed back to January 1st, 2021. And similarly, that's probably why we haven't seen too much movement on the other areas of compliance, the other regs since then. But we do know that there's a lot of pressure from disability advocacy groups on the federal government to get these things moving ahead. So again, we think probably 2021, we're going to see a lot more movement on these. Next slide, please. So all this slide really should tell you is that, not surprisingly, there are enforcement mechanisms developed. Again, depending on which sector you're operating in, will depend who is in charge of enforcing the act as against you. Next slide, please. And not surprisingly, those enforcement authorities have a lot of the usual enforcement powers. So they're empowered to conduct inspections. Most of the work, we think, again, similar to how Ontario has played out, will be done through compliance audits. So every year you're going to have to file your compliance or file your compliance report with the appropriate entity and the regulatory authority. And then based on those reports, we expect there'll be audits following up, trying to identify areas of non-compliance, and employers who haven't filed reports, for example, will be targeted for audits. If you're identified as being non-compliant, there are the powers to issue warnings, penalties. You can enter into compliance agreements, setting out the timeline for achieving compliance. There is an opportunity, again, to publicly name and shame employers who haven't come into compliance. But drawing on the sort of purpose of the legislation and the Ontario experience, there's much more of a focus on trying to aid with compliance and aid employers to come into compliance, rather than focusing on the penalties. However, the big difference here, as between any of the provinces, is that there is an individual complaint mechanism. So in the provinces, there's no opportunity for an individual to file a complaint and get a monetary penalty, for example, in the event of non-compliance. In this case, there is, and it's very much following the existing Canadian Human Rights Act formula and approach. Excuse me, but individuals will be able to file complaints challenging employers and saying that their non-compliance has caused them individual injury somehow, and correspondingly be entitled to damages for up to $20,000, going to be indexed to CPI going forward. And that's just for sort of the general damages. And on top of that, there's compensation for specific injuries, like a claim, for example, that someone didn't get a job because of the job posting, because the job posting requirements weren't adhered to. So that's going to be an area that's much more difficult for federal sector employers. Next slide, please. So I think, again, the key lessons from the provincial experience that we've seen is the overall intentions not to be punitive. There are going to be resources to help employers comply. In Ontario, we saw lots of draft plans and policies, templates that employers could use. Because, again, the goal is to try and get employers to change their behavior. It's not to go out there and penalize them. However, the addition of this individualized complaint process certainly makes it more difficult, and the stakes for non-compliance a lot harder. What we do see in the provinces is a lot of the requirements are achieved through training and policies. So we can expect that there are going to be a lot of those requirements coming into effect as well. But again, until we see the actual regulations next year, we're anticipating, we won't know exactly what's involved in that. So a lot of it is stay tuned, and we will certainly keep you updated as the regulations come out and are finalized. I'll pass it over to the next slide, please. to John and Chris to talk about key case law developments.
Thanks, Jackie. So that was all of the legislative change that employers are currently facing. There is a lot. But it is important to note that there have also been some case law developments over the past 12 months that federal employers should be aware of. Next slide, please. One of the most notable decisions to come out over the course of the last 12 months was the Supreme Court's decision in Canada Post and Cup W, which addressed federal employers' occupational health and safety obligations under Part 2 of the Code. Now, this is Supreme Court litigation, so there's obviously quite a tangled and lengthy history of underlying decisions and facts here, and we don't have time to get into all of them. Suffice to say that this litigation, this Supreme Court decision, addressed the scope of an employer's duty to ensure that the quote-unquote workplace is inspected every year, once a year, by the workplace committee. The issue in this case really arose from the fact that the Part 2 of the Code defines workplace as any place an employee works, not just locations that are under the actual control of the employer. And the problem here was that one of the employer duties, the specific duties in Section 125 of the Code, says that an employer must ensure that a committee inspects the quote-unquote workplace, every part of the workplace, at least once a year. So the question became, how does this provision apply to a workplace that the employer doesn't control? So a location where employees are working, but the employer has no physical control over or other control. And in this case, the issue was related to Canada Post letter carrier routes and their points of call, the addresses to which Canada Post letter carriers deliver the mail. Here, a committee had complained that Canada Post was not ensuring that all letter carrier routes and points of call were inspected every year. And that may sound ridiculous to you, the idea that a Canada Post or any other federal employer, given the nature of federal workplaces, would need to be out there ensuring that everywhere their employees work every year is inspected. But in this litigation, the Federal Court of Appeal of all adjudicative bodies agreed with the employee representatives here. The Federal Court of Appeal said, yes, a federal employer, based on the wording of the statute, is required to ensure that all aspects of the workplace, including areas that are not under the employer's control, are inspected by the committee every year. Happily, the Supreme Court took a different view and clarified, and this is judicial review, so there are some I guess caveats around reading this interpretation as applying to every other situation and every other federal workplace. But in this case, the Supreme Court said, no, that's not how the legislation needs to be read. And a federal employer, in this case Canada Post, is not required to ensure that every part of the workplace, including all locations that an employee works, are inspected by the committee every year. Rather, the employer only needed to ensure the inspection of the workplaces, the facilities that it actually controlled. So that decision was December 2019, a really welcome bit of news in respect of employer occupational health and safety obligations under Part 2 of the Code. John, I'll turn it over to you to deal with a few other cases.
Okay, thanks very much, Chris. This is really the year of legislative reform. But there were, as Chris mentioned, some important developments in the case law and also in collective bargaining. And so I thought I would end, and we don't have a lot of time, obviously, with just a few things to highlight that occurred. And the first is, over the past year, there were two decisions of the Canada Industrial Relations Board where the board actually relied on Section 2D of the Charter and the jurisprudence under Section 2D to interpret provisions of the code and to interpret or define the board's own jurisdiction remedially. And I find that very interesting for those of us who have been following along, wondering how the evolving jurisprudence on freedom of association from the Supreme Court would impact labor boards, and particularly our Canada board. And in both cases, you can imagine it was not favorable to the employer. In Swissport, it was unusually the employer who brought the unfair labor practice complaint against the union for engaging in bad faith bargaining. The union had engaged in bad faith bargaining and had then proceeded to give strike notice the employer brought an unfair labor practice complaint, sought interim relief to try and stop the union from moving to a strike. And although the board found a prima facie case of bad faith bargaining, the board relied on Saskatchewan Federation of Labor and the principles around the importance of collective bargaining and the right to strike to deny the request for interim relief to stop the union from proceeding to engage in an actual strike. The board fashioned a different kind of interim relief that it said would level the playing field. But as a result, the employer, who in that case was the applicant and arguably the victim of the unfair labor practice, was on the receiving end of a strike immediately after the board issued its interim relief decision. So maybe that isn't such great news, but it is very interesting for those of us who follow that area of the law. Next slide, please. In terms of collective bargaining highlights, there were a number of rather interesting collective bargaining rounds that came to a conclusion this year. And if I could go to the first, just to highlight, CN and the Teamsters, it may seem like a lifetime ago given all the things that we've experienced over the past year, but it was a year ago now that the Teamsters were striking at CN Rail. And what's notable here is that although there was a lot of pressure, the federal government did not impose back-to-work legislation. Parliament wasn't sitting at the time, and there was, I think, some sense of pressure coming on the parties to resolve it in any event. And they did reach a tentative agreement that was ratified in January 2020, to their credit. And I put the wage increases of 2.5, 2.53% on the slide. But I think the interesting note there is the parties got their own deal, and the federal government did not formally intervene in that. Next slide. Next slide, thank you. And then for those of you who are wondering what on earth ever happened to Canada Post and Cup W, well, here you go. The binding arbitration that it was imposed by the back to work legislation from November 2018, that binding arbitration process came to an end with an award issued by arbitrator Elizabeth McPherson in June of 2020. Next slide. She was bound under the legislation by statutory guiding principles, an unusual number of them, some that seemed to favor the union, others that seemed to favor the corporation, and one was collaborative labor relations. So that was her guide. And if we could go to the next slide. She issued her award. It was very complicated. There were numerous complex operational issues. Her award was very long, dealing with all the issues in dispute. But I found one thing notable, which is that she imposed wage increases because it was retroactive to 2018 of 2, 2, 2.5, and 2.9. And you may be wondering where on earth 2.9% in 2021 came from. And she actually wrote that it represents the arbitrator's best effort to predict the likely average wage increase for the federally regulated private sector in 2021. So for those of you wondering what the average wage increase is going to be, arbitrator McPherson gave us her prediction in that award. And next slide, please. Finally, Air Canada and Unifor concluded their negotiations in March 2020 within a collective agreement for the customer service and relations employees. And once again, Air Canada achieved a longer term agreement, 6 years. That's been a consistent approach by Air Canada to achieve long-term collective agreements for the stability of the organization. And I've put up the wage increases. I just noted 2021 at 2.0%. Didn't seem to conform to the prediction from arbitrator McPherson, but still notable. And Charles, did you have anything you wanted to add on collective bargaining developments?
Not really. For the sake of time, I believe we don't have time to cover, but it's basically the same topics that I've heard also in the market with respect to the actual and the more recent negotiations that we've dealt with.
Very good. So that's it for my little spiel at the end on things you may not have noticed or may be reminding of. Thank you.
And with that, I think I'll take it over to questions. So thank you for everyone who's been submitting questions as we go through. We'll stay a couple extra minutes past 3:30. I know we've only got 2 minutes left now, but we'll do our best to answer some. And I reiterate Chris's comments, please, that if you have specific questions, reach out to any of the panelists or your regular Fasken labor lawyers, and we'd be more than happy to help you. So one of the questions I had related to, I'll take it myself because it relates to the Pay Equity Act and what to do if you have an all-female workplace. So that's an excellent question, and that's actually been contemplated by the regulations. So the draft regulations that were released on Friday have a very detailed and very specific process for how employers can look to other employers within the same industry, or if not even the same industry necessarily, but other employers who might have similarly valued work and job classes, and can turn to those for guidance. So I would encourage you to look at the draft regulations as to how that process plays out, because it's, again, very, very technical and specific. The other question that also related to pay equity, which I'll touch on, is what to do with specific executive employees. So, for example, if you've got a female executive, how do you deal with them in the pay equity regime? And I would just highlight again that it's really, the Pay Equity Act is focused much more on job classes. So it's not about individual complaints of discrimination as between one executive and another. That would still form the basis of a discrimination complaint under the Canadian Human Rights Act, or it could. But rather it's looking at the classes that are gender dominated. So if a class of executives is typically associated with as a female dominated class of executives, then you would compare that to other job classes that are of similar or equal value under the pay equity regime, rather than looking individually. But on the executive point, I do note again that your pay equity committee is going to have access to a lot of this compensation information. And there are protections around confidential information in that process, but still, once you know information, it's very difficult to forget about it. So there are protections to try and ensure that individuals can't rely on that information in other processes, like collective bargaining, for example. But practically, of course, we know it's going to be much more difficult than that to enforce. Chris, I have a question for you. We had one question from the audience about psychological injury. Do we have a sense yet of how that's going to be interpreted, and what's really what falls within the scope of psychological injury?
Yeah, no, that's a really good question. I guess the short answer is that we don't yet have detailed interpretive guidance as to how the new Bill C-65, both legislative provisions and regulations, are going to be implemented and interpreted in practice. That said, we do have the interpretive guidance that has been applied to date to the existing workplace violence provisions in Part 2 of the code. And one of those interpretive guidelines does try to put some arms around this concept of psychological harm that has already been in play to some extent to date. And basically what the relevant interpretive IPG, the interpretive guidance from ESDC, says is that that you need to distinguish between psychological harm or psychological impairment on the one hand, which would be captured within the definition under Part 2 of the code, and on the other hand, something that psychologically affects an employee, which is not captured. And basically the example that the interpretive guidance gives is that, something that upsets or frustrates or makes an employee dissatisfied, that isn't the type of harm that is intended to be captured and prevented by Part 2 of the code. However, if you cross the threshold and really get to the point where the conduct at issue has actually impaired an employee's ability to function in the workplace or to function at home in their personal life, so some sort of more serious psychological stress, presumably something that is a recognized condition or a diagnosed condition by a medical professional of some sort, that type of impairment, that type of harm is captured by the concept of psychological harm underneath, or psychological harm under the old framework, and psychological injury under the new Bill C-65 framework.
Super. Thank you, Chris. I have another one for you quickly, Chris, before you go. And thanks everyone again for participating today. We'll wrap up after this one because we do have more questions, but I'm afraid I know everyone here has other places to be. So we appreciate very much you all joining us and taking your time so far. In the investigation process, I think you touched on this, but just want to confirm. Mm-hmm. So, is it possible to go straight to an investigation rather than going through the early resolution process, or is that really a mandatory process?
No, it's not possible based on the way in which the regulations are drafted. And of course, this may be subject to and probably will be subject to future detailed interpretive guidance from the labor program and ultimately probably from adjudicators in courts. But currently, the early resolution process is a mandatory part of the process. An employer must, as a first step, engage in early resolution efforts with the parties involved to try and resolve the issue of harassment or violence. And they must begin those early resolution efforts within 45 days of receiving a complaint. And only then, after those efforts really have gotten going, do things like conciliation and the investigation process come into play.
Super. On that note, I think I will, on behalf of the entire team, say again, thank you very much for joining us today. We appreciate you slotting us into your very busy schedule, and we look forward to seeing you at the next event. Thank you.